He walked into court thinking it would be just another hearing, routine, predictable, forgettable. But that illusion shattered the moment the judge leaned back in his chair. The room fell still, every whisper dying instantly. Even the defendant stopped fidgeting, sensing something was off. The judge's eyes narrowed, not in anger, but in calculation, as if he'd finally connected the last missing piece. And in that heavy silence, everyone realized the same terrifying truth. The judge wasn't buying the story anymore. What came next would not be a question or a warning, but a turning point, a moment no one could escape.
Happy to see you, Judge. Happy to see you, Mr. Allen. I have documents to submit.
What? Oh, just
David Morse on behalf of Plaintiff Pleasant Lake Park, LLC.
thank you.
Thank you.
Your name, sir?
Christopher Genoviak.
Okay. And what documents are you trying to submit to the court?
A counterclaim.
Have you?
Judge.
So this is our fourth hearing. Last hearing, plaintiff presented an inspection, an unsworn statement by an inspector, and Mr. Genowiak asked for 1 week to get his own inspection done. I understand that he has done that. He provided me a copy of an inspection report today, just before the hearing, and I understand from the Register of Actions that he filed a motion to set aside default, which maybe is the counterclaim. I'm not sure.
I don't understand how I submitted money. I don't know if I did that. I don't understand how I submitted money. I don't think I did that correctly.
How you what?
The money that you ordered to put in escrow,
Yes.
it's like a holding. Like, you may give me all the money back, hypothetically. I don't think I submitted the money correctly. Because I don't want to I put $12.30 in escrow because there's a $20.
You did.
Where are they putting this over here?
I don't know. They also made him fill out this form. That's why.
Oh, I see.
I told you about
Yes,
that.
you did.
Yeah, I think I did that.
No, the money, the escrow's there. We had a clerk that, I don't know why they did this. What they did, counsel, is apparently the only way that they ever saw escrow come in without an understanding that I ordered escrow was on a motion to set aside.
I see.
And so they had to fill out that form, which really means nothing because there is no judgment had they looked.
Yeah, I'm ignorant of my actions. I don't know.
No, it truly, sir, there may be other things that are your fault. This one's not. So, well, okay.
The
You
proof.
can hand it to me when I want you to hand it to me. You really do not have to bow. Okay. Have you seen the counter complaint?
No, I'm not aware of a filed counter complaint. And for the record, I haven't seen a copy of an answer, haven't seen any writings by the defendant.
Okay, so let me just back up a second. What did your report reveal?
It revealed conspiracy and perjury by the landlord, Mr. Weasel. And
Oh my gosh.
investigators.
No.
Oh.
You had an inspection.
Yes.
Or,
Oh, the inspection determined that there is a complete infestation
of what?
of rats. A complete infestation. There's rodents everywhere. Throughout the home in areas like the rotary room and wide open, and you shouldn't see this is usually a sign of an infestation. The loose material underneath the dresser and behind the stove is from the rats trying to create a nest. The loose material behind the stove is from the stove's insulation. And be very.
Who's this from?
It could be a fire hazard. This is from a company called Proof that has over 100 years.
It's from.
I have colored photos and I have
You
the jump.
had-
It's licensed and insured.
Okay, just let me,
Would you like a copy?
thank you.
Thank you.
I gave the kind lawyer a copy of this. Sorry. I don't know if that's, did you give him what I gave you?
Yes.
Okay, so we have. Right. That is what I have. So the most sort of technician comments are, there are more pictures I did not.
Okay, were
complete-
these pictures a part of his report?
Yes, sir. Yes, Judge. This is,
Okay,
I haven't slept a single night since August. I called the police twice because I thought there was people outside my house, but it's really just a rat infestation. I've tried to get resolved and they wouldn't do walkarounds. So since August, I haven't.
called the police on the rats?
This is the rats, yes. There was more creatures. The whole house was just, there was holes in the skirting and there's proof. There's holes in it underneath the cabinets that are connected to the wall. It's a complete rat hotel. I hear them every night. They chew my property. This is a complete opposite of what this client said. His inspector is my next door neighbor. There's a conflict of interest in here. There's conspiracy. There's
Okay.
perjury. I might take this to trial to get them on record, so I can later sue them.
Okay,
I might take this
all
to trial
right.
to get them on record.
Okay, all right.
I might. You're judge.
Well, we welcome any trial if you would
I'm-
like to file an answer and a counter complaint. Your Honor, frankly, this is the first that plaintiff is hearing of rats. And this whole case it's on non-payment. For weeks or maybe months, the defendant has been complaining of a beaver or a badger under his premises. My client has been taking steps like trapping, poison, inspection under the premises, outside of the premises. We file a non-payment complaint and the defendant still did not raise this issue. First hearing, second hearing.
Trust me, counsel, I remember everything
Thank you, Judge.
on this, and I just. What's in your counterclaim?
My counterclaim, Judge, has a photo evidence of a complete rat infestation, the complete opposite of what.
Okay, but is that the counterclaim?
I mean, this is enough for his client to be convicted of perjury and conspiracy.
I don't know what that means. I'm just asking, is that your counterclaim?
Yes, Judge.
Can I see that? And counsel, I'll let you take a look. I'm trying to.
The judge opened the file slowly, each page turning like the ticking of a countdown. "We've danced around this long enough," he said quietly, but the softness in his voice only made the words sharper. The defendant swallowed hard, his lawyer shifted nervously, the gallery leaned in. The judge continued, "I've reviewed the evidence, the testimony, and the excuses, and now we address what's been avoided." A chill ran through the room. No gavel needed, no raised voice, just a calm declaration that felt heavier than any shout. Because in that moment, everyone knew the truth had finally cornered him.
Oh. Lord have mercy. Here. It's the report.
Yeah, that's mine. Yeah, this just proves everything that he's been saying the whole time. Because this is a licensed and insured rodent pest control with over 100 years of experience. And his rodent and pest control man lives on the same property that Mr. Weasel owns, which is a conflict of interest. And he's not licensed or insured. The inspector doesn't even own his own vehicle. He lives with his kind elderly father. And he used this.
Sir, do you understand that
I don't understand.
is not, it's clear that is not a counter complaint.
Should I put it in writing?
Well, that's usually where it starts.
Okay,
Yeah.
I know there's an order of operations and proper, ways of operating here. I thought this was sufficient for the court, that this is a professional who's licensed and insured with multiple lines contradicting the plaintiff's claims. And I want to make a deal. I want to leave. I feel like I'm being attacked.
You want to go?
My deal is, my proposed deal, is not a serious one. I do want to go, but.
I don't know what that means.
Yeah,
What do
yeah,
you mean?
I would like to hear a deal. I could propose a deal, but I mean, I really want to stay here and get this rats out of my bedroom. It's literally in my bedroom. It's literally I have a stick just to poke the rats underneath the dresser. I literally have a rat stick next to my bed. For the record, I literally have a rat stick next to my bed for 5 months. So I can put this in writing. And I'm sorry to waste court time. I've been trying to make a deal, but I tried to do a walk around and I tried to do a proper investigation months ago, but
Okay, sir,
yes,
there are certain ways that you would have to do an answer and a counter complaint. Okay? And you need paragraph by paragraph laying out your allegations as against the plaintiff, as well as answering the plaintiff's claims in this case. You follow me?
No, I don't understand. I thought I did that when I first did the paperwork for the contract. Like, it says like, how do you respond to the claims? And I was just like, yeah, I disagree with everything but like the money portion. So, I just thought this was like pretty cut and simple. Like, if there's a fly in your steak, you're not going to charge it with potatoes.
But sir, you started out with like a beaver or some large like badger type animal under there. Then when you came back the last time, we weren't talking rats. You were talking about mice and the baseboards being ground zero and all of that stuff.
Yeah.
Now I get here today and now these mice have grown and now they're rats.
Oh yeah, the problem's gotten way worse. I agree with you, Judge. Problem's way worse now.
You're not really saying the mice grew into rats.
I'm saying that the rats have been there the whole time and that we haven't done a proper inspection. We haven't done it proper since the get.
All right.
Sorry, Judge.
Sir, go ahead.
It's plaintiff's position that to the extent this is a defense about habitability, that this is the tenant's willful and that the tenant has caused these through irresponsible conduct or lack of conduct. To the extent he has a rat stick or anything else, this is the first plaintiff is hearing of it. This should have been.
A rat stick.
This is to the extent the landlord should have trapped, should have baited, should have taken any steps, we needed to have been made aware. We were not made aware. It's clear to me that defendant has taken no meaningful steps to resolve the issue. His living conditions invite the issue, and that we can't be in a position, the landlord cannot be in a position to check in on the defendant to ensure that his quality of life is where maybe it should be. I submit to the court that there is no tribal issue here. To the extent the court disagrees or believes that there should be another chance to file something in writing, I think this needs to go to a trial, a short trial.
I want a bench judgment.
I'm sorry?
I want a bench trial. Judge.
Well, that's all you're entitled to at this point because I don't have a jury fee. So
Correct.
So
one other point for the record, Your Honor, is that management understands that. So there have been attempts to go out for the beaver or badger, and there have been attempts to assist with skirting and other various issues raised over the months. Management has been responsive, but understands that there was at some point, defendant in the last month or so made a comment to a neighbor saying that he would shoot management if they came and knocked on his door. He also claims that management has stolen hamburger off of his counter. So we're not sure if these allegations or threats are real, and we have to assume that they are. And this is part of management's concern, is that, frankly, that the situation has broken down, and I think a trial would show that there were no attempts to bring management in on the rat, the mouse, or other issues other than the badger or beaver. And those have been proven or shown through the unsworn statement to be flatly false. Mr. Janowiak's inspector clearly did not see any signs of a badger or beaver either.
Hey, so how long is it gonna take for you to put your complaints in writing to the court?
I don't understand what I should put,
Well, you're gonna need to understand.
because I thought this was, so I'll put, so I know I'm not asking you for legal advice.
Good,
But I
I
need to
won't
just-
give it to you.
Right. So, and this is quite the maze. And that's my ignorance. So I can put something in writing within 7 days, once I understand what to put, that's gonna be acceptable to the
All
court.
right, you're gonna need to get to figure it out in the next 2 days. The defendant to file a written answer.
A written answer to what? A written answer
To the complaint.
to the complaint, and the complaint is what, Judge? I don't know, I don't understand what the complaint is.
All right, you got served with a complaint. That's what brought you here. You need to file an answer to that complaint. And if you got a complaint against the landlord, you need to file what's called a counter complaint, or your complaint against him. That you keep trying to hand me is not a complaint. It is not a counter complaint. It is nothing for the court at this point.
I don't understand. So I will submit what I will, so,
You're to file a written answer and or counter complaint.
to the
You're
clerk.
to do that by December 3rd.
Yes, Judge.
Filing of that will only be complete once you file it with the court and you serve counsel with a copy,
I don't understand how to serve counsel.
usually by email.
I don't have proper access to email all the time. That's why there's like,
Okay, get a stamp, put it in an envelope and send it to him.
it's gotta get it twice a year, basically. Judge.
No, you gotta, when you file it with the court, you have to serve them a copy because you have to acknowledge that you've given them a copy of what you're filing with the court. Then, so you're to do that by December 3rd. I will give you time to look at that. I'm gonna go right to final settlement conference on it. And so I'm gonna set a final settlement conference on this case, which is the step before we go to trial. Set that for December 9th, 2025 at 9 a.m. That is in person, and all parties must be present. Now, I'm going to let you know, I want you to understand this, sir. I have a lot of latitude if you don't follow the court's directions. So if you don't file an answer or a counter complaint, but if you don't submit something in writing in its proper form, I'm going to grant them possession. I'm going to grant them a judgment. I'm just going to let you know that.
I will submit a written response. So,
Is there anything else?
no, Judge.
I have great trepidation to ask.
What, trepidation?
Never mind.
Could you define that?
Never mind. No,
I don't
I-
understand what trepidation.
I'm saying I didn't really want to ask you if there's anything else because I didn't want to hear anything else. All right? Just to be blunt about that. But as a matter of courtesy, I have to make sure that everybody's been heard.
Yes, Judge.
Is there anything else?
No, Judge.
Sweet. Thank you. Everybody have a good holiday. Is this your only copy, counsel?
Yes, it is.
All right, so
I will-
I'll. Court could stand in recess. I'll be right back, I swear.
All right. Aye. You may be seated.